I think if you could kindly adjust your camera, we are able to see the table, sir.
I'm not able to see my photo, in fact, my image.
Yeah,
Okay.
because we are able to see the photo of table, sir. Table. On which you
no
are
problem.
sitting.
So you are able to hear me, na? That's
Yes, sir.
okay.
Perfectly.
That's right.
Sir, if you could switch the side of your camera, that would work perhaps. Ma'am, we'll begin sharp at 4. Is that all right?
Yes, wish.
Thank you, ma'am.
With the permission of the guest. Okay.
Oh.
Yes. If the guests and the faculty members may permit, shall I begin the session?
Oh, sure.
Yes. Okay, sir. So with your kind permission, we are beginning. Yes,
Yeah.
Radhika, please.
Yes.
Yeah.
Thank you, ma'am. Greetings of the day to all. I'm Radhika Gupta, moderator of today's webinar on behalf of Flexcom, the Corporate Law Society of Vivekananda School of Law and Legal Studies. I welcome you all to the national webinar on corporate criminal liability with special reference to white-collar crimes. I would like to extend a warm welcome to respected Professor Dr. R. Venkata Rao, sir, Chairperson of VSLLS and VSES, Professor Dr. T.V. Subba Rao, sir, Professor Emeritus, our respected Dean Professor Dr. Rashmi Salpekar, ma'am, our Associate Dean Professor J. Ravindran, sir, our esteemed panelists, Senior Advocate Mr. K.K. Manan, sir, and Senior Advocate Mr. Siddharth Luthra, sir, and our Assistant Professor Sonia Man, ma'am, the faculty convener of Flexcom, and all the other faculty members present with us. And finally, a hearty welcome to all our attendees. We are honored to have you all gather at this digital hall of learning and skill building. I would now like to welcome Professor Dr. R. Venkata Rao, the Chairperson of VSLLS and VSES. Sir is a former Vice Chancellor of NLSIU Bangalore. He was awarded Professor N.R. Madhav Menon Best Law Teacher Award of the Year 2018 and the Attorney General K. Parasaran Award in recognition of his outstanding scholarship in legal education by Capital Foundation Society in New Delhi in 2019. His achievements are par excellence and his work is lauded worldwide. We welcome you to this digital podium to address our panelists and the attendees, sir.
Thank you very much. Am I audible to you?
Yes, sir, you are audible.
Hello.
Yes, sir, you are audible, sir.
Am I audible?
Yes, sir, you are audible, sir, please.
Hello.
Yes, you are audible, sir.
Hello. Hello.
Yes, sir. You are audible, sir. We are able to listen.
Oh, yeah. Thank you. Thank you.
Yeah,
Because
yeah.
there's a problem of connectivity. Okay,
Yes,
right.
sir. Yes,
I
sir.
will come and sit.
Yes, sir. Please, sir.
Yeah. Now, I can start.
Yes, sir. Please.
Yeah, thank you very much. Most esteemed and revered, in fact, Dr. Rashmi and my student friends, I congratulate you. Today is a double dhamaka for us. You have invited two of the best and eminent persons in the field. The former chairman of the Bar Council of Delhi, senior advocate Sri K.K. Mananji, and Siddharth Luthraji, to participate in this national webinar on corporate criminal liability with special reference to white-collar crimes. And most revered Manan Saab and Siddharth Luthra Saab, Dr. Rashmi, young friends, distinguished colleagues, it's my privilege to extend a very warm welcome to you to this wonderful national webinar. And we are grateful, beholden to Mananji and Siddharth Luthraji for having taken the time of their extremely busy schedule, which only proves the fact that it is only a busy man who finds time for the cause of the young law students. Before I welcome you, sir, two words about this wonderful institution, VIPS, and Vivekananda School of Law and Legal Studies. Now, just 1 week ago, Guru Govind Indraprastha University has announced the list of gold medal winners. And with all humility, I submit to 5 of our students have bagged the gold medals of Guru Govind Indraprastha University from the Faculty of Law. And about 15 days ago, our students won the distinguished Bennett Moot Court Championship. And therefore, this evening, when you are interacting with them, our students would stand to gain immensely, and it would be a deferred dividend for them. When I look at the topic, corporate criminal liability with special reference to white-collar crimes, my special congratulations to Lexcom and the student friends for having chosen such a contemporaneous topic. Now, when I rummaged through the newspapers, if it was Yes Bank day before yesterday, and if it is Bharat Pay yesterday, and today if you have Mysterious Yogi and NSE, Chitra Ramakrishnan, or if you have the fraud hit housing corporation, Dewan Housing Corporation, which are only illustrative, you would find as to how much fraud has been taking place because of the so-called laxity in corporate governance. And what will be its impact on society? Now, Sutherland in his book, Criminology, says the impact of white-collar crimes would be much, much greater than the impact of traditional crimes. And therefore, sir, 2 or 3 points come to my mind. The first one is people say about illegal related party transactions, RPT offenders. Now, how much fraud is taking place because of this skewed ownership concentration and because of the failure to adhere to 4 pillars of disclosure. In the world of corporate governance, say you must be digital, you must be diligent, you must be transparent with disclosures, and you must document thoroughly. But how many of us have been doing that? Now, this is a very important point to be taken into consideration. The second one is a very interesting aspect about corporate social responsibility requirements. In fact, in 2019, for instance, the government proposed to amend the law to treat non-compliance with corporate social responsibility as a criminal offense, though this amendment was later softened to a civil offense in 2021 after the industry lobbies protested. But the question is, is there a transition from a discretionary regime to a mandatory one? And has it become more explicit? And the most important point is, what about the role of independent directors? Are they really independent or are they independent? And thereby making a very important segment of watchdogs conspicuous by its absence. So these are some of the emerging dimensions in corporate criminal liability And my grateful thanks to both of you for having accepted our invitation. With these few words, it's my privilege to extend a warm welcome to K.K. Manan Sahab and Siddharth Luthra Sahab. Over to you, Rashmi. Thank you very much.
Thank you so much, sir. Thank you so much. And now both guests, they have joined us. We are welcoming you. Thank you so much, sir. Yes, over to you, Radhika. Let's go ahead.
Thank you so much, ma'am. I would like to introduce the first speaker of the day, Senior Advocate K.K. Manan, sir. He's a renowned and a par excellence criminal law practitioner with an enlightening career spanning for more than 4 decades. Sir has served as the chairman of the Delhi Bar Council in 2007, as well as in 2014. He is known for his bold arguments before the court and his meticulous take on issues and contributions to various high-profile cases. He has appeared as a standing counsel for the central government before the Delhi High Court, and he has also represented the Bar Council of Delhi before the Delhi High Court in the fake law degree row. And the list goes on. We welcome you, sir, to enrich us with your experience.
Thank you. First of all, I would like to say thanks to the organizers, panelists, and my younger brother, colleague, rising star in the bar. And I can say that I am a disciple of his father. Late, everybody knows his name. Luthra Sahab was a guide. I mean, father of Siddharth Luthra ji. His sister is also a senior designated lawyer. He has also started his career from trial court, but now he is one of the top lawyer of the country, Supreme Court especially. Whatever I know, little bit, I will share my experience so far as white collar crimes or the crimes committed by the companies. I have personal experience being a lawyer of large of clients, I can say large of people who have committed, but as per ethics of the profession, I will not name them, but at the same time also I'm responsible and answerable to the society. Being lawyer, I don't shy to say anybody can engage us. We can't deny. We can deny only when we say that we don't have any time. Number of reasons are there to deny a matter, to deny a case of somebody, or to deny a client's case. Anyway, that is not the topic today. So far as white collar crime is concerned, this is, I can say, non-violent crime where the primary motive is typically financial in nature. White collar criminals usually occupy a professional position of power or prestige, and one that commands well above average compensation. The term white collar crime was coined in 1930 by sociologist and criminologist Edwin Sutherland. He used the phrase to describe the types of crime commonly committed by persons of respectability, people who are recognized as possessing high social status. Sutherland eventually founded the Bloomington School of Criminology at the State University of Indiana. Prior to Sutherland's introduction of the concept of white-collar crime, the upper classes of society were thought to be largely incapable of engaging in such criminal activity. Such a belief was so deeply entrenched in society that when Sutherland first published a book on the subject, some of America's largest companies successfully used to get the book heavily censored. What are the characteristics of white-collar crimes? You see that affect not only the health and material welfare of the individual, but also the economic structure and social fabric of the nation, and are committed by middle and upper class people. Poor people can't commit. You will find it if the poor people or a constable taking 200, 300, 500, 1,000 rupees bribe, he will be convicted within 1 or 2 years. The person will be scot-free, like Vijay Mallya, Nirav Modi, number of others. I will not name them. One of them I named, but I also represented him somewhere. Anyway, now the question is, a few days ago, again, 22,000 crores in Gujarat, 10,000 crore last week again. It is not possible without the connivance of the bank officials. It is not possible without the connivance of high-ups. And neither the bank officials, somewhere, sometime the bank official used to be prosecuted or convicted. But my personal experience and perception is that without the connivance of the bank officials, bank loan on a forged documents or the property papers which are forged one being I can say checked by somewhere, few lawyers also being engaged by the banks to go through the papers, verify the authenticity of those papers. They also take money from the persons and say that papers are genuine. They have gone to the site, property is there, though nothing is there. Not one, I think more than 100 people I have represented who are being and prosecuted, few convicted also, few acquitted also. Surprisingly, time and again I said on the TV also, whenever any big fish was caught or run away, I said there is no, big issue to bring them back here. Sometime can't be, but like now Dubai is a heaven for these people, especially for builders. Why don't you cancel their passport under Section 10 of the Passport Act? In Dubai, you convey them, inform them that such and such person entered in your country, his passport is cancelled. He will be deported by the Dubai authorities within 10 days, sometime 2 days. But the investigating agency don't do this. One of the case, day after tomorrow, I'm appearing. Main person absconded and he has looted Himachal Pradesh and few banks more than 22,000 crore, for which excise officials of Himachal Pradesh, bank officials, Patwari, Tehsildar, DC, all were connived with him. However, he made 2 or 3 employees, the directors, they were paid directors, they have been apprehended and they are behind the bar. And they don't have any assets. They were paid like a employee, but the big fish living in Dubai, no steps are being taken. Likewise, I'm coming again on the mode of commission is fraud, misrepresentation. Unlike force commonly associated with the traditional crimes. Victim is usually the state, or even when the victim is an individual, the harm is to the society at large. The act mostly deliberate and willful. Now you will find it somewhere I also don't agree, though I bow my head before the Honorable Supreme Court, before the Honorable High Court. You see, number of builders put behind the bar for indefinite period. Their projects are lingering now. By keeping them behind the bar, will their project will be completed? Somewhere the Honorable High Court or the Honorable Supreme Court took measures, made a group or given to those home buyers of society or whatever you can call them, a group was formed, they will construct. They will not be able. They are not the perfect persons to do that. Yes, of course, there should be a way out. How to get the construction done through the builders, either by keeping them behind the bar or by hanging this board on their head. If they will be released on interim bail and complete the project on such and such period, if they don't do, put them behind the bar for some time more, they should know. And at least the Honorable Supreme Court also should give an indulgence to the authorities, few like CBI, FERA, ED, that how they have siphoned the money abroad. In one of the case, though I will not name, when I was asking my fee, they said, मर गए, कुछ नहीं रहा, भूखे मर गए, किराए पे आ गए. After a few days, I found another criminal in jail itself promised him to give 200 crores for getting the bail. 40 crores paid, and to pay that man a famous another thug sitting in the jail, enjoying in the jail. Every person, big person, you will find that they are enjoying in the jail. Jail is now a second home for them. If the court is of the view that they are suffering in the jail, no, they are being provided every comfort in the jail. And because jail authorities are also not Mahatma Buddha, they are also not saints. The corruption in jail more than the outside police. You go in any jail, you can find any facility in the jail. My learned friend will agree with me. He has also a vast experience that by keeping a person, especially the white collar person, though the Honorable Supreme Court say and is of the view that the white collar crime is worse than a murderer. But I don't agree with this proposition. It's my perception, but I bow my head, whatever the perception or view of the Honorable Supreme Court or the High Court, because money can be earned again. If the person die, he can't revive. So one cannot, of course, that the health, economic health of the country, equally important. No doubt in it. But this white collar crime is in fact a global phenomenon. And India is no exception to it. The emergence of white collar crimes in India can be traced back to the advent of British colonization during the period of industrial capitalism. The vicious cycle, once started at that time, has today spread its tentacles to almost every profession and area, including in my area, my profession. Don't shy. I don't shy because I'm dealing a lot of professionals in the bar council, how they are indulging. The white collar crime, which was in the nascent stage then, has today emerged as a full grown offense and has been posing a challenge to the justice system. The greed and lust for money has not spared even the noble and honored professions of the country. The legal, medical, and the education sectors all today are gripped by the temptation of unethical practices. It has become a common phenomena in the legal profession. I'm coming on my profession as well. You see that we are also not a saint. Sometimes it pinched. Even for advocates to abet wrong to serve their narrow interest, fix cases for their rich clients, arrange professional witnesses, fabricate evidence. Advocates of today blatantly violate the ethical standards of the legal profession and act in complete objection of pious oaths to serve the society. I was the chairman bar council when my colleague, he was the chairman of bar council, I will not name him, a very famous case, car accident case. I took the action when that media has started, then NDTV. I took the action against my colleague. He was my chairman once upon a time in the bar council. Another was my close friend, both my seniors. But I did not hesitate to take the action because friendship is a different thing. When I found that if they are really, one was let off, another was let off by way of a fine because he was already scolded by the Honorable Supreme Court. Another important profession in the grip of unethical practice is the medical profession today. It has become a common practice among the medical practitioners to adopt dilatory practices in providing treatment to the patients. They also indulge in various unethical practices like issuing false medical certificates, carrying illegal abortions, giving misleading and fake advertisement claiming absolute treatment of an illness. Doctors often misguide patients as to the procedure of a treatment and make them consent to it. Educational institutions also form an area wherein white-collar crimes have become predominant. Privately run institutes submit fake details of their college and get financial aid from the government. If you remember that I also, again, the second time when I became the chairman bar council, Delhi sitting law minister, I was the chairman at that time. I had given him full opportunity. Off the record, Luthraji, I got inquired before giving the case to the police, his even BSc and law degrees. At least bar council in my time and thereafter also, in Jhansi, at least in and Bihar also, they don't do practice there, but in Delhi, you will find it. Still, a lot of people are there having fake degrees. Fake degrees. But unfortunately, this board system has eaten the society like politicians. We are worse than them. Even I will say that my fellow colleagues, for the sake of boards, they don't inquire about their degrees, get them enrolled also. Few days ago, one case came to me. Unfortunately, that man, or fortunately, belongs to my village. area nearby. Retired from a army. His one son is a IPS, another is IS. Highly qualified. His degree was found jali. Case was registered in Hoskas police station. He came to me. He said, neither I applied for the bar council, nor I had gone to the law college. I called the investigating officer at my residence. Look, this man is a such and such status. And immediately, because bar council office is not far away from my house, I called the original file and put it before him, Luthraji. He said, these are not my signatures. These are not my signatures. I never knew it. I said, how your photograph has come? He said that once two people, one lady, one gent came, one person came at my residence, that you have not to go, Mathura, there is a college, you have not to go anywhere. You will have the degree. I said, no, I will not. But if you can get me the admission, I will go there in the evening classes sometime. I have given my certificates and the photograph. Thereafter, neither I have taken this degree, nor I applied before the bar council. So somewhere, then I pointed out in the bar council that somewhere some gang racket is going on in Delhi bar council. So we are trying to catch hold. We are giving the complaint to the SHO and bringing the things in the knowledge of the DCP also. So you will find it that you see that number of things are in the society today. Now another, you see, the area is recent years, the bribery and corruption have become on increase in India. Various high profile cases of corruption have become political and election issues. The sad state of affairs is that sorry, taking or giving bribes has become very prevalent among the government officers. Government officers holding posts like IFS, income tax officers, are frequently caught by the enforcement agencies accepting the bribes while doing their work. And it's a very common. Now, the Indian criminal laws have plethora of legislation to tackle the means of giving or accepting bribe. Bribery is an offense that involves two parties. The offense, the bribe giver and the bribe acceptor. The legislations framed to tackle this offense have made it punishable at both instances, at the instance of giver as well as accepting. One of the important pieces of legislation in this regard in the Prevention of Corruption Act 1988 that criminalizes receipts of any undue advantage by public servants and provides such undue advantage to other persons. The Act targets middlemen also who facilitate bribery. The Act provides penalties in the form of imprisonment ranging from 6 months to 10 years and fine or for which no amount is mentioned. Now, I can give you an example. The most corrupt person, you go the corrupt officer in government, you go at his residence. Broken sofa, very pathetic condition of the house. His address would be like that one address or two dresses the whole years. But after retirement, he buy a house in South Delhi. Why the government, after their retirement, at least they should watch his activities and his whatever the properties he may make or made after 10 years. There should be some provisions. Even a lot of, I will not name. I'm giving the hint my learned brother can see, before joining such and such, residing in Pitampura, now in defense colony after 7 or 8 years. How? Whole life you could not buy the Maruti car. Now you came and your children are coming in Mercedes. How it is possible? How it is possible? Siddharth may not say, but I will say on behalf of him, he must have, must be sleeping not less than 12 o'clock in the night. Wake up at 6, 5, 6, maximum 6:30. Me like that also. Overnight, though his father was a top lawyer of the country, his style neither he could nor I could adopt. His style of working, practicing, or living. He was a royal. You see that once, though it is not relevant, but I would like to tell you, when he came for the first time in the court premises, that was in Parliament Street. My seniors used to tell me. First day he came in a taxi at that time and gone back in a taxi. His clothes, shoes, one can see that how he was, and thereafter he said, I will not go on a motorcycle or a scooter again. Whenever, after 1 or 2 years, he had gone to the court in a car. So he made a style from the day one. I say dress and address counts in the profession. Whether you have 2 pairs of clothes, but keep it clean, properly ironed. And it is not the topic, but in our profession, now things are, I can't say anything. I don't want somebody say tomorrow that you are giving lecture such and such on us. Another thing which I'm now again touching, so then the legislature also made a few, enacted the law, I can say, the Right to Information Act 2005, black money, undisclosed foreign income and assets, and Imposition Act 2015, Foreign Contribution Regulation Act 2010, Fugitive Economic Offenders Act 2018, and latest one. So my now the approach today, what can I say? The agony, I can say that somewhere the investigating agencies are not honest to catch hold these white collars. They avoid the criminal prosecution. The strength of these acts lies immediate confiscation of all properties. Who does? You see, I'm coming on a very, it's my personal experience. Last year, one case came to me, and I asked him that how much money that you have to make to the banks. He said that 21 crore. How much money you have paid back? He said 12 crores. Property worth 50 crore he has given. Now Luthraji, see the plight of a man. 2 properties were of worth more than 50 crore actually. Bank auctioned one property which was worth more than 25 crore, only 3 crore. He said no opportunity was given to me. Otherwise, and this is another very big scandal which the government and the courts should look into. The property circle rate, everybody knows that in Delhi, circle rate is different than the actual rate. Gray market is there. Everybody knows it. One can't, close the eyes from the truth. So likewise, now so far as corporate criminal liability is concerned, this doctrine established in corporate criminal liability, one is the vicarious liability. The accused is blamed for offense of another. This doctrine is based on the principle of respondent superior, which means let the master answer. This doctrine is applicable in criminal as well as wherein corporate may be held liable and punishment can be fine and seizure of property. Company can't be, company is not a body, human body, who can be punished and sent to behind the bar. For that purpose, the doctrine of identification, it requires that corporation should take responsibility for the persons having decision-making authority for the policy of the corporation rather than the persons implementing such policies. The doctrine focuses on the fact that the intention and the action of the company are the results of the employees of the company. The underlying principle of this doctrine is the detection of the guilty mind, that is, doctrine of collective blindness, doctrine of willful blindness, doctrine of arbitrary attribution, doctrine of alter ego. You see that number of doctrines are there, but the ultimately question is whether we means the society, state, is getting the justice from the courts by prosecuting the corporate sectors. Have you found? Yes, of course, out of 100, 1 or 2 could be. I don't deny. But in whole, they go scot-free. Ultimately, few cases, famous cases, because I noted down, so I'm reading it from my, otherwise I was giving whatever, I'm sharing it from my personal experience, but few things which I have noted it, which I read over. The famous case laws are, there are offenses in the Indian Penal Code which describe the offenses of serious nature where under a corporate body also may be found guilty, and the punishment prescribed is a mandatory custodial sentence. In the case of Standard Chartered Bank versus Directorate of Enforcement, AIR 2005 Supreme Court 2622, it was held that the company is liable to be prosecuted and punished for criminal offense. The Supreme Court rejected the notion that the company could avoid criminal prosecution in cases where a custodial sentence is mandatory. As the company cannot be sentenced to imprisonment, the court cannot impose that punishment, but when imprisonment and fine are prescribed as punishment, the court can impose the punishment of fine, which could be enforces against the company. In another case, that is Anitha Hada versus Godfather Travels and Tours Private Limited in 2012. In this case, the dispute was related to deciding the liability of corporate and in dishonor of check. The Supreme Court discussed the extent of vicarious liability in case of corporate. The company, being a juristic person, is liable for the acts of others. In other case of Iridium India Telecom Limited versus Motorola, the Supreme Court held that in all jurisdictions across the world which are governed by the rule of law, companies and corporate houses can no longer claim immunity from criminal prosecution on the ground that they are not capable of possessing mens rea. So ultimately, which I feel, and in fact what I think, and in conclusion, I will say only one thing which I noted down, which I come at the conclusion that it is well settled law, principle in criminal law, jurisprudence regarding criminal liability on the corporations. Corporation may commit a crime and held liable for criminal offense. However, the statutes in India are not in pace with these developments, and they don't make corporations criminally liable. Even if they do so, the statutes and the judicial interpretations imposes no other punishment except fine. Even the Supreme Court said that there is a need for separate law making provision for infliction of criminal liability on the corporation. So whatever little knowledge or a little bit experience of my life, since I dealt criminal law in trial court also, though in these days I don't do, but started practice from the trial court. And so what I found ultimately, big fishes got scot-free in this country because dishonest investigating agencies don't shy. We are also responsible somewhere. Black coat with, I can't say connivance, but I will say, yes, we, after taking fees, help them to get scot-free because we have the license from the Bar Council. We have also duty, but at the same time, everybody is not guilty or is a person who has committed the crime sometime. As I said that I'm doing one case employee that he is the director, no doubt in it, but salaried director. But the main MD, the main person who looted the Himachal Pradesh and 3-4 banks, more than 22,000 crores and sitting in Dubai. But we have to convince the court that the persons who have been arrested by the investigating agency, they are not the persons, the actual person is such and such. What investigating agency? Now, another thing, investigating agency knew it. They know it that he is not in India, but getting his non-welfare warrants. What is the use? What is the use by getting the non-welfare warrants? PO or something else? So with these words, I have taken a lot of time, and I will say again, thanks to my panelists, especially the organizers and my learned younger brother. But I will say now he ahead of me number of steps. I'm proud of him. I'm proud of him. Younger brother or his father, wherever he is, must be very happy today. Must be very happy. His two children, both are doing very well, and I'm proud of them. And thanks once again.
Thank you so much, sir, for your address and for guiding our students. Thank you so much.
Thank you so much, sir.
Yes,
sorry, ma'am.
Yeah, so just now we have understood various dimensions of corporate criminal liability with special reference to white collar crimes. And in fact, sir has also touched that it is the responsibility of all of us, including educational institutions and an individual, to stand for the truth. So with this, I would like to request my student to kindly introduce our next guest, Senior Advocate Shri Siddharth Luthraji, and immediately then we will start with his address. Over to Radhika.
Thank you so much, ma'am. Introducing our second speaker of the day, Senior Advocate Siddharth Luthra, sir. He has made his mark in the profession for over 3 decades and was appointed as the Additional Solicitor General of India for the Supreme Court in the year 2012. He has represented the central and various state governments in numerous cases related to fundamental rights, electoral reforms, etc. He has appeared as the special public prosecutor in the Nirbhaya case. In addition, he has assisted the courts in various cases as an amicus curiae. Sir is also a visiting professor at the NLU Delhi and has also served as the member of the advisory board for 2 Indian legal journals, namely Delhi Law Times and the Delhi Reported Judgments. In addition, Sir has also organized the International KK Luthra Memorial Moot Court on criminal law within the Campus Law Center, University of Delhi, each year. So we welcome you, sir, to address this eager crowd.
Thank you so much, Radhika. Thank you, Professor. And I'm most grateful to my learned senior colleague, my elder brother, Mr. Manan. There are some legends in our profession, people who have worked their way up, who have struggled, and yet today have reached both recognition, professional respect, and popular acclaim. It's not easy. Successful lawyers are not very popular normally, but Mr. Manan is one of those rare exceptions because of his nature and his support to all of us. To us, to my sister and to me, he has been a friend to our family, an elder brother to me, and we have a very long and intimate relationship with the Manan Sahab and his family. And I'm one of his, I'm a member of his fan club, not now, but from the day I joined the profession. And honestly, this is a story. You see, people come from backgrounds where they have an asset or an advantage in the law. Don't look at them necessarily, but look at people like him who began at scratch and have a national name for themselves only by dint of commitment and hard work. And he has balanced his responsibility as a leader of the bar, as a regulator of the bar, as a member of the Bar Council, and a chairman of the Bar Council, as a senior advocate, and as a friend to many. So thank you so much for your kind words, Manan Sahab. A lot to learn from you. I'm still trying. I don't know whether I'll be ever successful. It's been very kind of him to be so gracious in his remembrance of my late father. I'm touched as always. He's very kind to me, and very kind of you to remember somebody who passed away 2.5 decades, but that's the grace of Mr. Manan, and that's also something you must learn from people, what sets them apart from the crowd. Manan Sahab has dwelt at length with his very vast experience. He has 4 decades of experience, and he's dwelt at length in some of the decisions I was going to refer, he's already cited. So I've made a short PPT. I'm going to just take you through the short PPT, but rather than the PPT, I'll share the PPT with you. I'm just going to take 10 minutes and run through some random thoughts. I apologize for this. It was so riveting listening to Manan Sahab that we were all engrossed, and I was also enjoying it. And that's the reason I will take lesser time, because I don't want to overburden you with unnecessary thoughts. The PPT can be distributed later, and if the students are so interested. White collar crime is an expression which is brought in, as pointed out earlier by Sutherland. Crime committed by a person of respectability and high social status. It distinguishes from blue collar workers. Traditionally in England, blue collar person was the worker. Blue collar worker was a person who was a worker who was working in a factory or as a manual labor, and therefore that was the distinction between white collar and blue collar. White collar, like lawyers also wear white collars. Now, this concept has been recognized in India way back. One of the classic decisions is Ram Narayan Popli, a 2003 decision of the stock exchange fraud, and even prior to that in Porwal's case, 1987. This term white collar encompasses a large range of crimes. It is a section of economic crimes, but not limited to all economic crime, because economic crime is a larger conspectus. As Manan Sahab said, there can be bank fraud, bribery, corruption, embezzlement, money laundering, tax fraud, securities fraud, forgery, cheating, breach of trust, etc., etc. Again, as he rightly said, when we use the word white collar criminals are worse than murderers, that's absolutely a misnomer. It's an absolutely wrong statement. Yet in Jagan Mohan Reddy's case in 2013, it said economic offenses constitute a class apart. But Jagan Mohan has 2 judges. Please look at Subba. Subba didn't draw a distinction. Please look at Sanjay Chandra. Sanjay Chandra said you can't draw a distinction. There is a decision, H.B. Chaturvedi of the Delhi High Court, which said crime and punishment has to be seen in the context of the sentence you give. In a murder case, you give a life sentence. In white collar crime, you don't. And if all of you look back to the jurisprudence of the 1980s, late 70s, definitely the 80s, you had judges like Krishna Iyer, Bhagwati, and others who were pro-liberty judges. Liberalization, is a period, and Manan Saab has shared with you his experiences as a prosecutor as well. Liberalization is a period which led to an economic boom of sorts, led to crime. He's talked to us about bank frauds of 222,000 crores and many others, and people sitting enjoying themselves in Dubai while millions are being prosecuted in India. Now, all of these point to an issue that there is a problem in the criminal justice system. It is leaking in a sense. But this leakage of the system doesn't mean that we should have harsher laws, reverse presumptions, restrictions of bail. An offense of cheating or fraud in the IPC has bail conditions, but not restrictive bail conditions. In the Companies Act, in PMLA, you have restrictive bail conditions. How do you justify an incursion on the presumption of innocence and a restriction on the rights of an individual? Is that not, and I ask you all, abhorrent to Article 21? Is that not a breach of Article 14? How can you apply these parameters? And these things need to be considered. Fortunately, the Constitution bench in Sushila Agarwal, I don't know if any of you drink. If you do, fine, but I will use an example. According to me, it's old wine in a new bottle, that's it. So Sushila Agarwal really reiterates what Sibya said in 1980 in the context of anticipatory bail, with a lot more language, some clarifications, because there was a lot of problems in the middle. Anticipatory bail had been really curtailed. It also overrules the Chidambaram decision on anticipatory bail. Most people don't realize it. And it says there are no fetters. So if the Constitution bench recognizes that economic crime ought not to be treated as a class apart, how is it that 2 judges benches and 3 judges benches of the Supreme Court are ignoring that law? As students of the law, are these judgments not per incuriam? And I would request you to examine this aspect. The issue of restrictive conditions and restrictive procedures is currently underway. The PMLA provisions are being argued as we speak. We've argued it on our side. Now the state is arguing, the Solicitor General is arguing, and we will see what happens in conclusion. There are numerous cases where you will find that economic crime leads to long periods of incarceration. When I began my criminal practice, and I began over a decade after Manan Saab, the principle was what we call the tripod test. Is the man going to flee? Is the person going to tamper with evidence? Has the person got roots in society? Is the person required to be in custody for any purpose of investigation? Today, our jails are overflowing. They're overflowing because judges are restricting bail. Is this justified? And let me tell you something about the numbers. In 2020, when Supreme Court decided to open out the jails because of COVID, you know, the statistics they used was of 2018. We didn't have up-to-date 2020 statistics, 2009. Let me also tell you a little more about, there are a number of illustrated cases, but there's one chart which I want to put up on the screen. Just allow me a moment. There's one thing I definitely want to put up on the screen, just to give you a little illustration. Just a moment. Let me just do this. There's one thing you need to see, guys, which is which I want you to see one. Yeah, now I want you to see this. Can you see this, please? Can you see the number of crimes? The number of from tax evasion onwards. I've just illustrated them. See the legislations. See the investigating agencies, and these are only illustrative. We are not looking at state acts.
This is what is showing.
Sorry. I don't think my screen is showing up, but no problem. I'll share this with you at a later stage. I think there seems to be an issue. But there are, just share it, please. Aap share kar dijiyega. I want to just show you this chart so you understand the range of white collar offenses. Can you, yeah, just open that, please. Just have a glance at that, please. Yeah, I think that's connected. Just put slideshow on. Current play from current slide. Just put play from current slide. Yeah. Just see that.
Yes, sir.
Just 24 illustrative offenses. And yet today, MRTP Act is no longer in vogue. That's now been overruled with the Competition Act. That's an error at the bottom. We'll correct it and send you a final version. But this is the range of offenses that we're dealing with today. Every aspect of human conduct from birth to death is being legislated by the criminal law today. Just leave it. Close that. There's another thing which I want to deal about, and that is the Manan Saab talked about the individual in Delhi who's being prosecuted while the employer and the main person is abroad. There is a principle of alter ego. India is one of those rare countries where since 1923, as at least I know, in the Official Secret Act, there was a vicarious liability provision which said if the company is an offender, directors will be an offender. All right. As a result, every director is prosecuted irrespective of their role. The second part of the provision says a person who has a specific role other than directors. So we said that if the corporate is an offender or the trust or the society is an offender, then we will impute liability to those persons who are in control, in charge and control, in charge and responsible for the day-to-day affairs of the company is the word used. But is that the correct test? Secondly, this test has been dealt with in a number of decisions. Manan Saab talked about Standard Chartered, Iridium. There are a number of decisions. However, is it not on the alternative, and that's a principle which we have not imposed very much, which was considered in 1996 in JK Industries, the JK Boilers case, which is the case regarding Factories Act, that when the individual at the helm of affairs commits the offense, should that individual not be the principal offender and the liability then, if it all gets imputed to the company? All over the world, it is the second principle that's being applied. We still stick to the first principle. Is that relevant today? Can you impute criminal liability as a matter of right or as a matter of presumption? I thought there was a presumption of innocence which governs our criminal law, but yet we recognize within our system the reverse criminal liability from corporate to the individual, not from necessarily from the individual to corporate, because eventually it's the individual that commits the act. The corporate may benefit. And that's something which needs redressal in our system. Of course, there have been some attempts that even within the existing vicarious liability provision, where we have said that if you don't prosecute the company, you can't prosecute. There's Anita Hada, Manan Saab pointed out, recent is Hindustan Unilever, then there's Dale D'Souza, number of decisions. Don't need to repeat or overbulk you with decisions. Now, the third part, and since I'm not taking this very long, I'm going to come to the third part is inter se disputes, commercial disputes in this country are now giving rise to a large body of criminal law. The lawyers practicing criminal law, and I do not want to call us criminal lawyers because to be called criminal lawyers makes it sound as if we are committing the crime. We are not. We are only lawyers who practice the field of criminal law. So let's have that very clear. Lawyers who practice criminal law are not complaining, but today it is so easy to convert a civil fraud or a civil action into criminal action. People lose limitation. People file it 10 years late. But the court says after, and I'll tell you where this was decided finally. Earlier, malafide was a ground in Bhajanlal's case to quash a proceeding at the basis, at the base itself. But now, the Supreme Court in the Birla versus Lodha case in Shivanath Prasad, which is a 2005-2006 decision, said malafides cannot be the basis for quashment. So supposing somebody cleverly goes to a creative lawyer, prepares a civil action as a criminal complaint and prosecutes, how do you escape that? But you face a prosecution. Is that just? Years of prosecution go on. You know, in some courts, a criminal appeal single bench after conviction takes 20 years to be decided. Manan Saab will tell you he has much more experience on his side. Single bench criminal appeals, even in corruption matters in the High Court, will, sir, if I'm not mistaken, not take less than 10-15 years at least, sir, to be decided. Maybe more.
Maybe sometime 20 years.
That's right. So look, the chairman of the Bar Council is telling you the facts. He's been, I must tell you, you must hear from him. He has so candidly told you what ails the system. Very few people are willing to talk like this, so frankly and so honestly. But the point is, there are things that ail the system. Of course, just as lawyers are creative, sometimes judges also accept our creativity. So now, malefides has now been sought to be introduced in a new avatar called abuse of process, which was already there, but it's now called abuse of process. And there is a classic decision which I would recommend, which is 2021, 5 SEC 435, Krishan Lal Chawla. It's now even says that a magistrate can throw out a frivolous complaint, delayed or time barred. But why does this have to happen at the Supreme Court? Why are we not throwing out at the threshold so-called white-collar crimes, which are really civil commercial actions? Why does it take a litigant years of time and money and clogs up the criminal justice system? As a result, our criminal appeals of convicts, as we have pointed out, don't get decided. People are languishing in custody. Murder appeals are not decided for 20 years. What are we doing to our system? I can go on and on because there is a lot to be said, but I will just leave you with an illustration. In 2013, 12 to 14, I was an additional Solicitor General, and I had raised the very same issue Mr. Manan has raised today about the competence of investigating officers in dealing with white-collar crimes. It was at the CBI raising day, and what was very fascinating was that in the evening when there was a dinner, the CBI young officers came to me and said, "Sir, we have this problem. You flagged it." I said, "Well, I flagged it, but what do we do?" He said, "Sir, we are young officers. Please speak to the director and ask him." So I told the director. Of course, that director changed, and since then many directors have changed. The results are there for all to see. It is so easy to fail to understand a commercial transaction, prosecute an individual and say, "Let the court decide." And this pen pushing, or this pushing of your responsibility at the threshold by investigators because of lack of understanding, is costing liberty dear. And it's a matter of course. See the number of decisions on civil versus criminal that are decided by the high courts every year. Just check 482s and revisions and SLPs, and you'll understand what I'm saying. I will end by saying this, that there is now Black Money Act, there's Fugitive Offenders Act. There is so many body of legislations coming down on what is perceived as white-collar crime. Punish crime, but don't criminalize conduct which is commercial or civil in nature. Otherwise, you are creating havoc in our society. Thank you very much. Thank you, all of you. Sir, I will take your permission to leave. My Professor Pandey's book launch is there. I have to.
Sure.
And Mr. Manan's permission. Thank you so much, sir. Thank you, sir.
Thank you so much, sir. Thank you so much for sparing your valuable time. Thank you. With this, Radhika, can we open the floor? With the permission of our guest, can we take, sir, few questions of students?
No problem.
Thank you, sir. Thank you. Yes,
Thank you so
Radhika.
much, sir. Yes, ma'am, I'm just opening the chat box for everyone. We also have circulated a questionnaire form. If the team could direct the questions towards the chat box.
If there are some questions which are of the same meaning, then you can club, okay, so that you can save the time. Yes, please go ahead.
Just a second, ma'am. I'm being sent the questions in. So one of the questions I would like to put up is there an effective, any other effective means of dealing with the corporate criminal liability? If you could guide us through the process, how they're generally dealt with, and how else could, what else can the judiciary do better to deal with cases such as these?
You see, for that purpose, the Honorable Supreme Court said that there are a number of times that there is a need for a separate law making provision for infliction of criminal liability on the corporations, corporate companies. Number of times, not once, twice, number of times, the Honorable Supreme Court, the Honorable various high courts observed it in the judgments itself. But unfortunately, the government somewhere is sleeping over such type of suggestions.
Thank you. Thank you for the explanation, sir. One of the questions is about the interconnection of Section 13 of the PC Act and white collar crimes. If you would guide us through that.
In my perception, that corruption, so far as Section 13 is concerned, 13 maximum government officials. So far as corporate is concerned, and this Section 13 is concerned, both are totally different. 13, though corruption is a corruption, it's a, I can say, some in the society, like it's a disease. Corruption is a disease, cancer, I will say. But at the same time, the crime, why white collar, in thousands crore. Earlier used to do cases of 420 or this corruption cases. Sometime some constable, sub-inspector, income tax officer, sub-inspector took 20,000 rupees, 10,000 rupees, 5,000 rupees. Now, for the last about few years, you will find it since Harshad Mehta. You see that white collar crime is in figures of thousands crores. And these big fishes always go scot-free. All of them almost are sitting abroad. They are unable to bring them back. How they go abroad? Without the connivance of the police, without the connivance of the airport authorities, without the connivance of the bank officials, they took the loan. What type of securities they have taken? As I said, that for that purpose, corruption, Section 13 will come so far as bank officials are concerned, as government bank officials are concerned, and so far as these white collar crimes that of private persons, corporations are concerned, that is why I say, and even the Honorable Supreme Court said, that they should enact a law, separate law for them. So their properties, and they should be, I mean, some stringent law should be there to deal with them, which is not there at the moment. As Mr. Luthra also said, I also told you, economic offenses crime cannot be compared with murderer. A murderer can be, minimum punishment is life, maximum death, and in corruption, 10 years maximum, 420, 7 years maximum. And I have never seen, even under Section 13 of Prevention of Corruption Act, 2 years, 3 years, maximum 5, 7 years. Now, except Lalu Yadav and Madhu Kauda, 1 or 2 persons. Now see the plight of this country. 1 or 2 years, Jagan Reddy was behind the bar. Still cases are against him, but he is the chief minister of the state. What message we are giving to the society? How the law is not, how the law can't be enacted that the person who has been arrested and kept behind the bar for such and such period, why bail was not being granted to him? Because the court was of view that he has committed an offense. That's why. Otherwise, bail would have been granted while he was arrested, or the anticipatory bail would have been given. Not only Jagan Reddy, number of persons are there. Now you have seen it. Second minister, first home minister of Maharashtra has been arrested. He is behind the bar. Now the second minister in Maharashtra has been arrested by the ED 2-3 days ago. See the plight. This is the white collar crime. This is the white collar crime. And before that, another person, Bhujbal or something, he remained in custody for about 1 year in FERA or by the ED people. Now he again either MLA or he is in the government. So the question is, the Supreme Court is also trying to get the information, how many cases, this and that. But ultimately, this country, I can say, is being surrounded by these white collar criminals from all corners.
Thank you so much for the detailed answer, sir. It was very enlightening to learn from you. A few more questions that we've received. How are the other countries dealing with white collar crimes? And if they're doing better, then why is India lagging behind? Or how could India do better to act at par with the other countries who are doing better at dealing with white collar crimes?
Though in other countries also white collar crime is there, but you will find it in other countries, not like our country, that the matter is pending. In one of the case, just my colleague is sitting with me, MS Uditi Bali. She has a sister in one of the case. He was arrested in 2000. Innocent person was arrested. He was an employee. After 20 years, he was discharged. He was dismissed from the service. After 20 years, he discharged by the trial court. His question is still pending before the Honorable High Court, which I filed in 2008. Till today, that number never reached. First, his further trial was stayed. However, in between, I said that if you are unable to decide my question, let me argue before the trial court. Ultimately, I argued before the trial court and man was discharged and he lost his service. See his age now, he is more than 70. At that time, he was about 50 and got his services terminated and ultimately found innocent. This is the, I can say, the judicial system is also required to be properly now reformed.
Thank you so much, sir. I believe that was the extent of our major queries. And if I could now invite Dean Ma'am, Professor Dr. Rashmi Salpekar, to give a vote of thanks. That would be really helpful for us. Our respected Dean holds a PhD in international law.
Yes, Radhika, it's fine. Thank you.
Thank you so much for your guidance, ma'am.
Sir, at the outset, on behalf of Law School of Vivekananda Institute of Professional Studies, called as VIPS, on behalf of VIPS, I would like to extend our heartfelt thanks to you that you have spared your valuable time for us. That is also on Saturday, and from 4 to 5:30 means I can understand that how valuable time this is. And you have spared your valuable time for our students of law and all the participants. So sir, on behalf of VIPS, I would like to thank.
Thank you very much.
I would also like to thank Mr. Siddharth Luthraji, senior advocate, that he has also spared his valuable time. In fact, since morning, he was having many meetings. In evening also, in late evening also, he was having some meeting, but still in between, he somehow managed to be here. So thank you so much, Shri Siddharth Luthraji, for your guidance. And sir, yes, I agree with you that all these, big people, somehow they have surrounded our country with their white collar crimes. But yes, in education institutions, sir, we are having hope. And
yes, of course.
And we wanted to nurture this hope. We wanted to nurture these young people, these young minds, of course, but we can't do it without your help and your guidance. So thank you so much, sir, for your address.
Once I also came in your institute.
Yes, sir.
And gave a lecture. I remember that, but I was in a hurry.
Right, sir.
So I said that I may be given the chance first, not in the end. And your chairman is also good friend of mine. We exchanged the good morning message.
Yes, sir.
But he gives me sometime in Sanskrit. Very good slogan. I mean, shloks.
Yes, sir.
So nice of you. Good luck. Best of luck.
Thank you, sir.
हिंदी में कहते हैं खूब बड़ो फुलो, बहुत अच्छे बच्चे आपके यहाँ से निकल के आ रहे हैं।
जी सर।
मैं देखता हूँ जब भी आते, मेरे पास इंटर्न बहुत आते हैं।
हाँ जी सर।
मेरे पास इंटर्न आते हैं ऑल ओवर इंडिया से।
जी सर।
ऑल ओवर इंडिया से, गांधीनगर, पूना, कलकत्ता,
राइट सर,
मध्य प्रदेश, भोपाल से, ऑल नेशनल लॉ स्कूल से, एमआईटी, लखनऊ एंड
yes sir,
बच्चे At least 100 बच्चा तो हर साल आता मेरे पास minimum. And I don't say no to anybody.
Sir, it means that
Never.
you are having mini India in your chamber.
No, but what can I give them? Only guidance, nothing else.
Sir, this is
बच्चे
only
खुश
we
हो
want.
जाते हैं.
This is only we want. And in fact, the students who intern with you, they always come to us and they always appreciate your guidance. And they always say that, ma'am, if somewhere we wanted to go, then please, we wanted to go once again to Manan sir. So thank you so much, sir. For your
बहुत बच्चे मैडम आते हैं आपके द्वारा लॉ कंप्लीट करने के बाद के सर, मैंने कहा बेटा मेरे पास पहले ही बहुत होते हैं, क्योंकि पहले मैं ट्रायल कोर्ट में था ना,
हाँ जी
मेरे
सर,
पास 20-25 रोज के केस होते थे,
जी सर,
समय नहीं होता था खाना खाने का भी। लेकिन
हाँ जी
अब मैंने ट्रायल बंद कर दिया, ज्यादातर कोई बड़ा केस हो जाए या कोई टीडीएस हो तो ले लेता हूँ।
जी जी
अदरवाइज मैडम देखिए, मैं किसान का बेटा हूँ। लूथरा साहब के फादर तो बहुत बड़े लॉयर थे,
जी
के
सर,
लूथरा साहब। मैं किसान का बेटा हूँ, गांव से चलकर आया हूँ, फर्स्ट
जी जी
जनरेशन हूँ।
जी
लेकिन
जी
अब तो मेरी जनरेशन क्या, मैं, मेरे तीनों बच्चे लॉयर्स हैं, दामाद लॉयर है, दोनों ब्रदर लॉयर हैं, भतीजा लॉयर है। और अपना ये सबको मैंने कहा भी, देखो ये बहुत अच्छा प्रोफेशन है। अपने नॉट गांव से, अपने इलाके से मैं पहला लॉयर बना था,
जी सर, जी सर,
पहला लॉयर बन के आया था।
हाँ
सो
जी,
आई वाज आर्ग्यूइंग ए केस बिफोर द डीवी एंड आई वाज अपोजिंग कपिल सिब्बल।
अच्छा,
See, then I said, my lord, if I would have been a son of a Hiralal Sibbal, I am a son of a farmer.
yes sir,
So Kapil Sibbal's father was also a topmost lawyer. He was sometime from Punjab, sometime from Haryana, Advocate General,
जी
always.
जी सर,
Because every word was a law in Punjab and Haryana High Court.
yes sir,
So we have started from the scratch.
जी,
So
yes sir,
with your all cooperation, guidance of my seniors, and with the grace of God, and with the, I can say I can worship my parents.
yes sir. That we should do. That we should do. Thank you so much, sir, for these encouraging words. And indeed, your these words and in fact your complete profile is an inspiration for all of us. Thank you so much.
Thank you.
Thank you so much, Reed ma'am. Thank you so much to the sirs. Thank you so much to all the faculty members. And thank you
Special
so much.
thanks to the organizers, Lexcom. Yes, I always appreciate the efforts which Lexcom is doing. And yes, in a very right direction, they are proceeding further. And I'm closely monitoring you, right? Because I want this particular committee should be a model committee for all other student clubs and societies which we are having. So thank you so much, Sonia ma'am. All credit goes to you. So thank you so much. Yeah. Good evening.
Thank you so much, ma'am.
Thanks. Shall I take your leave now? Yes.
Thank you.
Thank you.
so
All
much,
the best.
ma'am.
Yeah.
All the participants are requested to fill the feedback form before you guys exit the meeting. And thank you so much to the team. I hope it was a successful event. Thank you so much, Sonia ma'am.